now we've sort of got the overview. Let's talk about the claims process. And that's confusion, delay, and denial. I have some other words that I use for it, but there's a three-step administrative process. There's the initial application, the request for reconsideration, and the hearing. The IA is sent to a state agency called the Office of Disability Determination Services, DDS. And I have a nickname for them. It's Dumb, Dumber, and Stupid. That's a joke, but it's not a joke in that because of staffing issues, because of the lack of training, there's about a 90% denial rate. Now, that denial is also something that you contribute to, and that is no doctor records, no doctor support, a failure to accurately describe your symptoms and functionality, a failure to accurately describe your work duties. And I promise you, if you don't have doctor records or doctor support, there's a good chance that Social Security in the initial stage is going to send you out for a consultative medical exam, a CME. You got to go. But it's not unusual for an unqualified doctor to perform that. I recently had a pediatrician perform a CE in a case. And obviously, I'm objecting to the weight of that opinion because a pediatrician doesn't know a whole lot in this particular case about a back condition. So you got to go. Social Security does look at it. And if the judge is looking for a reason to deny the claim, they will give significant weight to that consultative exam and ignore what your doctor has to say. Because there's no treating physician role in Social Security. They're not bound by what your doctor has to say. The initial application is confusing, it's time consuming, it's easy to make errors. In my office, we actually help the clients complete the application, and it's a pain, but it's a process that needs to be done, particularly making sure that you have all your doctors listed. More importantly, you're given a good work history. When you look at the work history form, by the way, you'll see that it only asks questions about the physicality of your occupation and no questions about the cognitive aspect of your work and no questions about your interaction with others. I call it the psychosocial aspect of your work. So on the back page, the blank page of the work history form, I'm making sure that my clients are describing those types of duties. Now, right now it's taking about 250 days. In some parts of the United States, it's longer, and it's taking that long just for them to assign a claims examiner. So in that process, you need to continue to get medical care. We still want to be submitting those medical records and forms. Now, if your claim gets denied, as 90% of them do, you have to file what's called a request for reconsideration, and you have to do that within 60 days of the day of the decision, or you get to start all over again. It's reviewed by DDS, and they didn't get any smarter, and we still have that 90% denial rate. It's about 150 to 250 days to get a decision. And again, you can make mistakes. If you're getting new diagnostic studies, you're changing doctors, you're getting a new kind of treatment, there's been a change in your functionality, all that information should be submitted to Social Security. So once they finally open up the file, hopefully they'll look at the records and there's this additional information that should make a difference. If the claim gets denied a second time, the third appeal is called a request for hearing. And you got to file it within 60 days of the date of the denial, or you get to start all over again. Again, it can take 16 to 24 months or longer to get a hearing from the time of the initial application or longer, depending on where you live in the United States. The judge is going to be using the 5-step sequential evaluation, and they're not bound by that earlier denials. And the approval rates will vary by judge, unfortunately. 45-minute hearing, and in 45 minutes, you've got the first 30 minutes to put on your case. In my particular situation, what I think is key is the lack of claim development and the lack and preparation. And so I'm going to talk about this in our next slide. There are common proof problems that are going to sink a claim. One is generally not having a residual functional capacity form and an unfavorable CME. exam, incomplete forms, failure to cooperate with the Social Security Administration. So they say, we're going to send you to a CME, and you say no, or they send you forms and you don't fill them out. You don't return their phone calls. Your medical records don't tell the story of your symptoms and functionality. You don't have residual functional capacity forms, the right ones, or them not completed properly. And then there's a lack of proper claim development and a lack of preparation. I explain to my clients that claim development starts with you. I like my clients to do what I call a symptom and functionality worksheet that we like to look at before each doctor visit. We want to give the doctor a really good interval history of what are your symptoms and how those symptoms impact your ability to function with some examples. So, I have difficulties rising from a chair, and 5 times out of 6, I'm going to fall down. And if I fall down, I've broken my wrist, I've broken my elbow, blah blah blah, type thing. So, what is the symptom, and how does that symptom impact your ability to function? I can't stand up at the sink to even wash off a coffee cup because I get faint, my heart rate drops, my blood pressure, changes, and down I go. So think about your symptoms and think about how your symptoms impact your ability to function, and make sure that story is being told in your medical records. Now, the other part of the claim development, again, is that RFC form. If you're at the hearing stage, lack of preparation can be fatal. You can't go in and watch a Social Security hearing. So I've shot a mock Social Security hearing video, so my clients get to see it. But unfortunately, some people won't meet their Social Security lawyer until the hour before the hearing, and that's not how it should go. You should be working closely with your Social Security attorney's office and the attorney. 6 weeks before a hearing, in my cases, I send out something called the direct examination video. It's an hour-long video that goes through every question one potentially could be asked, and I'm teaching people how to truthfully and accurately tell their story. But we also have a direct exam worksheet where my clients will write out all the answers to those questions, and an updated symptoms and functionality worksheet. Then, as part of this preparation, I have a practice session with them. I go over the logistics of the hearing, but I play the judge, they play them, and we practice those answers so that they learn how to testify and explain all of the things that need to be explained in 30 minutes in a way that the judge understands. So lack of preparation, lack of claim development can be fatal. As part of that preparation, I do a memorandum of law, 5 pages long, and that's all we can do. And obviously, I'm there making sure that my client's testimony is accurate and complete. And I'm there to cross-examine the vocational evaluator and explain what it is the theory of the case is. Now, let's talk about these in greater detail. Inaccurate forms or incomplete forms, not completing them, not considering all of the disabling medical conditions, not providing complete medical information about the providers, the kind of diagnostic studies you've had, not providing medication information. And on the other side, we've got inaccurate work history. We have inaccurate information about the date of the disability, and we have inaccurate information from third-party sources. You're going to be asked to name some people who will be asked to fill out some forms. And I've seen what these people's forms have done to claims. They can destroy them because ultimately a judge has to determine your credibility. And if the judge thinks that you and your third-party source statement are exaggerating, then the judge isn't going to believe you. And the judge has the ability to determine your credibility, which can sink your case. Failure to cooperate, failing to call them back, failing to attend consultative exams, failing to attend a hearing. Medical records. I have a new medical term for you. It's DDD, document deficiency disease. And if you've ever read your medical records, and I read a lot of them, sometimes you have to translate what the medical records into English because they're very vague or incomplete. I try to make sure that the records are telling a story. And that might mean that we are supplementing the chart with that symptoms and functionality worksheet that I want my clients to fill out and be made part of the client's chart. Of course, the residual functional capacity form is crucial, particularly if the chart notes are deficient. But I will tell you that judges will say, well, how did we get from that chart note to this RFC form? Because I don't see this in the records. So the question is the chart clear? Is it generated by CPT codes, ICD-9 codes? Is it menu generated? Can you read the handwriting? Now, this all assumes, of course, that your doctor supports your claim. And if the doctor does not support the claim, it is my legal advice that you find another doctor, because you cannot win a claim generally, particularly these kinds of claims, without the support of a physician. Now, this is something that you need to be very careful about. You may be asked, well, how are you doing? And you might say, oh, I'm feeling better. Any new complaints? No, I don't have any new complaints. Any changes? No, my condition's the same. Well, that's vague. And that kind of language can be seized on by a judge as an indication that you've recovered and you're able to work. So I don't ever say feeling better. I feel fine. There are no new complaints. Make sure you're telling the doctor what your symptoms are and the functionality, and if possible, have that supplemental form as part of your medical record. Now, I think a good chart requires teamwork with the patient and the doctor, and it requires comments on functionality. In terms of exertion and non-exertion, what do we mean by exertion? That's pretty clear. Sit, stand, walk, stoop, bend, lift. Non-exertional is the need to alternate sitting and standing. Problems with bilateral manual dexterity, problems with pace, problems with concentration, problems with attendance, those kinds of things. And so if you're having trouble with sustained activity, you might want to say, I can only get out of bed for 30 minutes and I'm fatigued, and I have to take a nap for 15 minutes, and I have to take, and that happens, 5 times a day. So you're telling the doctor what the symptom is, the fatigue, how it impacts the ability to function. So a good chart should comment on your functionality and tell us true story without the need for a translator. The RFC form, you have to have the diagnosis as the basis of the diagnosis. We have to have a report of the symptoms. We have to have a report of the physical functional limitations, the cognitive functional limitations. And if it's a psych RFC form, it'll be much the same, except for it'll be the psychiatric functional limitations. So non-exertional impairments are really important to be developed in these cases. So postural limitations, manipulative limitations, environmental limitations, smoke, for example, mental and sensory impairments. You might have to alternate sitting, standing, elevate your legs. You may have difficulty bending, stooping, squatting. All of that should be in your medical records, but should be addressed in that RFC form, because ultimately we have to prove, for the most part, that you can't even do a sedentary job doing bilateral manual dexterity, maintaining the pace, production, and attendance requirements. So I'm always cognizant of, when I'm listening to my client, what are the complaints that they have that we can use to establish that they can't even do sedentary work. So if you've got difficulty with reaching, grasping, handling, fingering, relating to others, understanding or carrying out simple instructions, if you have problems with concentration or poor stress tolerance, those are the kinds of things that we want to be developing in your medical records. And as an aside, I want to tell you that many of my clients, as I said, are depressed and have problems with anxiety and panic attacks. Unfortunately, the Social Security Administration thinks that everybody's depressed, and that notwithstanding that everybody can work. So it's very difficult to win a pure psychiatric claim. And so I'm always wanting to develop both the physical problems my client has and the psychiatric or psychological problems they have, or the cognitive problems. I will tell you that judges will reduce those things to carrying out simple, routine, repetitive tasks. Simple, routine, repetitive tasks with minimal contact with the public, coworkers, and supervisors. So unless you're having psychiatric problems that are causing you to be Baker acted or institutionalized, the psychiatric complaints in and of themselves are just not going to be winning the claim. So your doctor's job is to assist in developing the evidence, making sure your story is told accurately and completely. And that's important because the judge is going to use that RFC to form the basis of the hypothetical. Now, I'm going to go and tell you a little story. And this is a story I tell my clients. When we get in front of the judge, there will be you and there will be a vocational evaluator. And that vocational evaluator will never have met you. They will have read your work history form. They will have listened to your testimony. And the judge is going to say something like this: Mr. and Mrs. VE, I want you to assume that this individual who has a prior work history of working in the software industry can sit for 6 out of 8 hours, stand 2, lift 10, but because of cognitive and physical issues is going to be off task at least 10% of the time. Mr. or Mrs. VE, could they go back to that kind of work? Well, the VE is going to say no, because while everything is generally light to sedentary based on a hypothetical, the one thing that throws it off is being off task at least 10% of the time. And in that industry, you got to be 100% on 100% of the time. That question was step 4. But now comes the $1 million question. And the $1 million question is, well, Mr. and Mrs. VE, based on that hypothetical, is there other work that this person can do in the mythical, not real world national economy in view of their age, education, skills, and my hypothetical? And the VE is going to say, Judge, they could work in a laundromat folding towels all day. Judge, they could work in a room all by themselves, addressing envelopes all day. They could work as a phone solicitor. Judge, they could even work at the local restaurant putting silverware in that nice cloth napkin. If the judge stops there and your lawyer doesn't ask any questions, you're going to lose, because that question was step 5. But if I say, whoa, wait a second, I want you to assume that this person can't engage in postural changes more than just 1/3 of the time. So turning right, left, up, down, standing up, they can only at best do that 1/3 of the time. I want you to assume that they have issues with their hands. They are having some problems manipulating things. So they can only do manipulative activity for 1/3 of the time. And, because of their fatigue, because of side effects of medication, they're actually going to be off task at least 15 to 20% of the time. And, because of all the constellation of their symptoms, they're not going to be able to meet the attendance requirements, and they're going to be missing at least 2 days of work per month. Now, Mr. and Mrs. VE, as we add these things to the hypothetical, can this hypothetical person do the jobs you identified or any other work in the national economy? And the answer should be no. But this hypothetical has got to be formatted to meet your specific medical conditions and what potentially a judge would find as your restrictions and limitations. And many times I'm taking my hypothetical from not only my experience, but from the residual functional capacity forms that are being filled out by the doctor. So I'm adding things to the judge's hypothetical. I'm doing my own hypotheticals. And ultimately, it comes down to what the judge is going to make of your credibility and what hypothetical they go with. But I'm also, as many lawyers are, setting this up for an appeal if a judge rules against you, because many times the vocational issues can be a good fodder for an appeal if a claim gets denied.